Litigation can be a complex and intimidating process, but understanding how it works is crucial if you ever find yourself involved in a legal dispute. Every lawsuit follows a structured path with distinct stages, each serving a specific purpose in resolving legal conflicts. Today, we're breaking down the 8 key stages of litigation to give you a clear roadmap of what happens when a case goes to court. Before diving into the specific stages, it's important to note that securing a skilled attorney with experience in your particular legal issue is one of the most critical steps you can take. Your attorney will guide you through the entire process, starting with an initial interview to understand your situation and advise you on how to proceed. The litigation process typically follows 8 main stages: investigation, pleadings, discovery, pretrial, trial, settlement, appeal, and post-trial motions. Let's examine each of these stages in detail. The first stage is investigation. Every civil litigation case begins here, as your lawyer gathers facts and evidence to support your position. This might involve collecting forensic evidence, medical records, or conducting informal witness interviews. The goal is to build a solid foundation of proof for your arguments before formally filing any documents with the court. Once sufficient evidence has been gathered, the case moves to the pleading stage. This is where both parties file initial documents explaining their basic arguments. The plaintiff files a complaint describing the alleged wrongdoings of the defendant and what they're being held responsible for. After being served with this complaint, the defendant has the opportunity to respond with an answer. They might ask for clarification, correct allegations they believe are incorrect, or even request that the court dismiss the suit entirely. The third and typically longest stage is discovery. During discovery, both parties attempt to learn as much as possible about the case through legal research, document reviews, and witness interviews. This stage often continues right up until the trial begins. Key elements of discovery include depositions, where witnesses provide sworn testimony outside of court, obtaining statements from various types of witnesses, and filing motions to resolve preliminary issues. Next comes the pretrial stage, which consists of meetings and negotiations between attorneys representing both sides. Many cases actually reach settlement during this period, avoiding the need for a full trial. Attorneys may discuss potential resolutions and prepare their final strategies if the case does proceed to court. If a settlement isn't reached, the case moves to the trial stage. During trial, both sides present their arguments before either a judge alone or a judge and jury. The process begins with selecting a jury if applicable, followed by opening statements from both sides. Each party then presents evidence and questions witnesses before making closing arguments. Finally, the judge or jury delivers a verdict, determining the outcome of the case. Following the verdict comes the settlement stage, where the final outcome is determined. In civil cases, this typically involves a monetary award paid by the losing party to the winner. However, collecting this settlement can sometimes be challenging, requiring additional legal steps to enforce the judgment. If either party is dissatisfied with the trial's outcome, they can move to the appeal stage. Generally, parties have 14 days after the decision to file an appeal, which sends the case to a higher court. The appellate court reviews the case record, looking specifically for legal errors that might have affected the outcome, rather than rehearing the entire case. The final stage involves post-trial motions, which the losing party may file before considering an appeal. These might include requests for a new trial or motions to alter the judgment based on perceived errors during the trial process. Beyond these 8 stages, there are several important considerations in litigation. Alternative dispute resolution methods like mediation and arbitration can be used at various points to resolve cases more quickly and cost-effectively. Litigation expenses can be substantial, including attorney fees, court costs, and expert witness fees, making it essential to weigh potential outcomes against these costs. For anyone navigating litigation, staying organized with thorough records, maintaining open communication with your attorney, preparing for potential delays, and being honest throughout the process are crucial strategies for success. Always consider settlement opportunities when they arise, as they often provide faster and more cost-effective resolutions than proceeding to trial. Understanding these 8 stages of litigation provides a roadmap through what can otherwise seem like an overwhelming process. While each case is unique and may not progress through every stage, knowing this framework helps you better prepare for what lies ahead if you ever find yourself involved in a legal dispute. With proper legal representation and a clear understanding of the process, you can navigate litigation with greater confidence and clarity.